on the University of London programme, the law of tort is obviously divided into the various torts that are part of the syllabus. So we have many torts, such as tort of nuisance. Can you think of any others? Negligence. What else?
Violence against Fletcher.
Sorry?
Violence against Fletcher.
Yeah, tort of violence against Fletcher. Defamation. So those are the main ones that we look at. But negligence is the real bread and butter. Negligence is the central tort that we look at on the program. Now, negligence, which you don't know about yet, negligence is simply carelessness. Another word for carelessness. So the tort of negligence is about giving people a remedy when they suffer injury because of another person's carelessness. And that is a very, very broad principle. It's a principle that covers so many areas of human activity that it's very hard to narrow it down to a simple set of principles. But we do. And we do because of one important case that most of you will know about, and that is the case of Donoghue versus Stevenson. Now, this is a case from the 1920s, ended up in the court in the 1930s, but it was a case involving manufacturers' liability. The story involved two women who walked into a cafe, and one woman buys the other woman a ginger beer. She goes to the counter and buys the ginger beer. So here's our structure already. Here's our claimant. Right? That's our claimant here. So her friend buys a ginger beer from the cafe. The cafe has bought that ginger beer from a manufacturer. Okay? So from a manufacturer. Now, our claimant here drinks a ginger beer. However, this is not any old ginger beer. This is the most important bottle of ginger beer in legal history. Why? Because when this ginger beer was being manufactured, here's the bottle of ginger beer in the factory. A snail climbs up the side of the ginger beer, sits on the top. Here's our snail, very happy because he's about to make legal history. All right, the snail dives into the bottle of ginger beer, lands here, dies obviously, and decomposes. And our claimant eats that, swallows that decomposing snail. Becomes violently ill. Horrible story. So she tries to sue anybody she can possibly sue. The difficulty is that there's nobody to sue. She can't sue her friend because her friend got her the ginger beer as a present. She can't sue the cafe because she has no contract with the cafe. So could she possibly sue the manufacturer? The company that produced the ginger. Why does this matter? Well, this matters because back in the 1920s, there was no consumer protection legislation. There was no social medicine. So if you got sick, you lost your job, you couldn't go to work, you carried the cost of any injury you suffered yourself. Why could she not sue the cafe? Why can't she sue the cafe?
Because she wasn't in direct contract with them.
She has no contract with them. And what's the difficulty she has suing the manufacturer?
She didn't buy it directly.
Sorry?
She didn't buy it directly.
She didn't buy directly from them. And have you studied contract law? So what's the doctrine in contract law that says?
Third party principles.
Yes, but do you know the name of the doctrine?
Privity.
Privity of contract. Because of privity of contract, she can't sue the manufacturer. Privity of contract says you can only sue a contract if you have a contract with the person you're suing. So she can't sue the manufacturer. So this goes to the House of Lords. And in the House of Lords, Lord Atkin makes an interesting decision. He thinks this is very unfair, that she can't sue anybody involved. So he says that in the law of tort, there is a commonly understood principle. That is the principle that one owes a general duty of care to those who could be reasonably foreseeably affected by one's careless acts and omissions. Now, that's a big statement. He says that whatever we do, we have a duty to take reasonable care for the safety of other people. Whatever we do. We don't have to have a contract with people. We just have a duty to take reasonable care, not to injure other people. And he says because of that general duty of care, the manufacturer can be sued by the claimant. The manufacturer owes a duty of care to the claimant. He calls this the neighbor principle. He says we have a general duty to take reasonable care for the safety of our neighbor. Who's our neighbor? Well, then he uses a kind of circular argument. He says, my neighbor is anybody who could be reasonably, foreseeably injured by my acts or omissions. It's a kind of circular argument. You might ask the question, well, where does Lord Atkin get this from? Does he derive it from another case? Read the case and find, well, where is he getting this from? And there's no case. He simply made it up. He made it up. He said this is a well-established principle in British law, but he didn't say where it came from. Because it wasn't a well-established principle in British law, because if it had been, somebody would have thought of it before then, and this wouldn't be the case that we look at. This was not a well-established principle. This was a political decision. That's what makes tort interesting, because tort is about, not just about questions of right and wrong, but a question of how to allocate resources in society. Should the cost of accidents be borne by the people who suffer the accidents? Should they be borne by the people who cause the accidents? Or should they be borne by the state? Tort and the neighbor principle establishes here that the wrongdoer must carry some of the cost of causing accidents and causing it. That's a very, very important case. Now, out of that case, we have the entire tort of negligence. And this tort of negligence covers every sphere of human activity. It's what is used when someone crashes a car and hits someone. It's what you can use if you're injured by a brick falling off a building. It's what you use if you trip over a pavement or you are injured at work. All of these invoke the tort of negligence. This is a general principle that doesn't rely on the existence of a contract. Very, very important principle. It's a kind of umbrella tort. It covers a huge amount of different kinds of situations. And most of what you will cover on the tort course is about the tort of negligence. Now, since this case, there have been many reformulations of the test here in the case of Donoghue versus Stevenson. Donoghue versus Stevenson. Some of you who've studied tort already might know some of the reformulations. Can you remember any of them? Sorry? Other reformulations of the same test? There's the reformulation in Annes versus Merton. And there's another one. Sorry? I can't hear.
Adam versus Gabe.
Yeah, Adam versus Gabe, but the most important ones would be Ans versus Merton, Murphy versus Brentwood. Now, I don't really have time to go into these, but they reformulate the test. But the most important reformulation we find in this case, the case of Caparo versus Dickman. This is the one you want. And Caparo versus Dickman takes the principle in Donoghue and Stevenson and it redefines it. Let me tell you how. The case of Caparo versus Dickman concerns an auditing company. What auditors are? That's not an auditor. What is an auditor?
You look at your financial statements and tally them with your actual spendings and see whether you're financially sound or not.
Exactly. It looks at the financial records of an organization. It assesses them. It's a legal obligation whereby companies have got to make their reports available to auditors. It's a branch of accountancy, let's say. It's like accountancy, but even less exciting. Right? Now, so an auditor prepares a report on every company, and that report is publicly available. In this case, a company made its records available to an auditing firm. The auditors prepared the report and wrote a pretty good report. And on the strength of that report, many people bought shares in the company. It's publicly available. However, the report was wrong. Different kinds of people bought shares. You had existing shareholders who looked at the report and said, oh, that's good, I'm going to buy some more shares. But you also had new shareholders, people who were looking for somewhere to invest, and they said, well, I'm going to go with this company, it's got a pretty good report. Those two groups of people bought shares. They all lost money. And when they lost money, they wanted to sue the auditor. The structure of that is very, very similar to what we had here. So here, let's say, we have our auditor. Here is our company. And here is our shareholder. Okay? Now, the shareholder doesn't have a contract with the auditor. Shareholder didn't hire the auditor. The company hired the auditor. So, privity of contract makes it possible for the shareholders to sue the auditor. Sue the auditor. So they tried to sue in tort, in the tort of negligence, claiming that the auditors had a duty of care to do the reports properly. So, did they have a duty of care or not? In this case, the House of Lords found that in order to decide whether there's a duty of care, you've got to look at three criteria. The three criteria are as follows. One, is it reasonably foreseeable? Is it reasonably foreseeable that injury will be caused as a result of the auditor's carelessness? That's the same test as you find in Donoghue and Stevenson, isn't it? Same criteria. The second criterion was proximity. Is there proximity between the shareholders and the auditors? Proximity here was an issue of proximity in time, or space, or relationship. And the third criterion, is it fair, just, and reasonable to impose a duty of care? And here in this case, they said it wasn't fair, just, and reasonable to impose a duty of care. Because they said these reports, these auditors' reports, were not prepared for shareholders. They were prepared to satisfy a legal requirement that companies have to file financial reports. So it's not fair, just, and reasonable to impose that obligation on auditors, to make them legally liable for any injury that might be produced by a bad or by a careless. So this is now the test for duty of care in negligence. This is the test that we have. Okay. So duty of care in negligence. It's the first step in establishing a negligence claim. Without a duty of care, you can't go any further. There are other steps, of course, in the tort of negligence. What are the other steps? Can you tell me? After you establish duty, what's the next thing you must show?
Causation.
Sorry?
Causation.
Not yet. Before you get to causation?
Breach of duty.
Yes, you've got to show a breach of duty. Then we have causation. And what's our fourth step?
Damages.
Nope. Any guesses? That's causation. Fourth step is remoteness. The damage must not be too remote. So the entire tort of negligence is summed up in one sentence. Negligence takes place where a defendant owes a duty which they have breached, causing damage that is not too remote. Each one of those steps must be satisfied. And we are today only looking at the first one of those steps, at duty. So Donoghue and Stevenson and Caparo versus Dickman are only concerned with that first step, the duty of care. Is there a duty of care? We haven't said the duty is being breached, or that the breach has caused the damage. Just, is there a duty? Now, I want to just do one other thing before I finish with this very short section on tort law. And that is to say that duty of care is the most dynamic area of the law. It's the area where the most interesting cases happen. It's the area that changes the most. It's also the area with the most controversy. Let me give you an example. In Britain, over the past 20 years, there's been one area of duty of care that has changed more than any other. And that is the issue of the liability of public authorities. Do public authorities owe a duty of care to individual citizens? Now, why is this important? Well, this is important because public authorities are the institutions and organizations of the state, or the institutions that perform public service. Things like the fire service, the ambulance service, universities, teachers, the health service, all of those public elements of the state. Now, duty of care is a general principle. All of the cases we've talked about so far concern private organizations, But surely this will only mean anything if we can use duty of care to sue public authorities, to sue the state, to sue, for example, the health service when it carelessly results in someone's death, to sue fire services when they, let's say, don't put out a fire, to sue teachers or schools when they fail to provide a proper education, and so on. On the one hand, you can say, well, that's great, that's what we want. On the other hand, if you allow all public authorities to hold duty of care that's too easily litigated, then you won't have any public authorities. If somebody is unhappy with their education and they sue their school, well, lots of people are unhappy with their education. Then we would have no schools. So there's got to be a limit drawn somewhere. And this limit, I think, is a very difficult one. I'm going to talk about two cases. One is the case of Hill versus Chief Constable of West Yorkshire. Hill versus Chief Constable of West Yorkshire. Have you come across this case? You've done it? Yeah? Okay. It's quite an important one. Let me just say a little bit about it. Now, this is a 1996 case. The case involved a city in the north of London called Leeds. Leeds is a very large Pakistani population. I'm very good about houses. But apart from that, in the 1990s, it was also home to a serial killer. And the serial killer became known as the Yorkshire Ripper. And he was going around the city, abducting women and murdering them. The police were obviously looking for him. And they had a good idea that this particular guy might be the serial killer. He was a suspect. And one night they stopped him. He had one of the victims, body of one of the victims in the car, roof of the car, trunk of the car. But they never opened the back of the car. So they let him go. And he went down to kill two of them. And so when he was finally caught, the relations of the women who were murdered were very angry with the police. Because they said, well, the police, they didn't do their job. So they sued the police. They said that the police owed a duty of care in the tort of negligence, take reasonable care to make sure that they caught the right guy. It's the same principle as in Donoghue and Stevenson. Same principle in Caparo versus Dickman. Did the police owe a duty of care to catch serial killer? Now, this is a difficult one, isn't it? Because if you say they have no duty of care, well, you're just saying police obligation to the public is meaningless. But if you say they do have a duty of care, then you're creating a very heavy burden on the police to catch criminals. And the court here found for the police. They said there was no duty of care. Why? They said there was no duty of care because this was a failure to act and not an action. It was an omission. So they said you've got to make a distinction between a careless omission and a careless act. And they said it would not be fair, just and reasonable to impose an obligation on the police to take positive action to catch criminals. Of course, police have an obligation to catch criminals, but they don't have a personalized legal duty of care, which is a different thing. So they said it would be against public policy Now, you see the logic. The logic here is that the police should not be under too much pressure from the lawsuits to catch criminals. They have a general social obligation to catch criminals. But they've also got limited resources. And you also don't want to put the police under pressure to catch people all the time because they might catch the wrong person for fear of being sued. The police might be under pressure, for example, to falsify evidence, to extract convictions by torture, or by illegal means. And the British police have a history of doing this, by the way. As you may know from the Birmingham 6 cases. Yeah. So there is a history in Britain of the police bending the rules and lying about confessions. And so the court here said that it was counter to public policy to impose a duty of care, take positive action on the police to catch criminals. However, last year, there was another case. And the case, which you probably don't know yet, it's called Commissioner of Police of the Metropolis. Versus DSD. Okay, and the citation for the case is 2018. UK Supreme Court. Now, I think this is a very, very important case because I think it shows you the cultural change and legal change that has taken place in the United Kingdom since the Hill decision. The Hill decision was back in 1989. No, we're reading. We'll finish up. But for the next one, we'll need slides. Okay. This case of Commissioner of the Police versus DSD. Again, this is about a London situation. A murderer, serial killer, who was driving around London in a taxi. You know, secret to black taxis. And he was abducting women and murdering them. And by the way, this doesn't happen all the time. Well, it's not what's happening this week? Oh, I think it's a serial killer. Again, similar situation. The police had very strong evidence what this guy was. They failed to act and he went on to kill someone. The relations of those people is with the police. Very, very likely evidence. But there's a difference. The Supreme Court applied the Hill criteria. But they said now there is a different feature. That feature is human rights. And they said the difference between this and the Hill case is the 1998 Human Rights Act. Can you tell me what does the 1998 Human Rights Act do? Exactly. Incorporates the European Convention on Human Rights into British law. It means that all of the rights in the European Convention on Human Rights can be used to interpret common law. One of those rights is Article 3. Someone tell me what Article 3 involves. Sorry? It's one of the rights of the convention. Oh, no. Sorry, Article 3 of the convention, not Section 3 of the Act. Any idea? Can't remember? It's a hot day. Any idea?
Torture.
Exactly. It's the right to freedom from torture, inhuman and degrading treatment or punishment. Okay? That's one of the rights of the European Convention on Human Rights that is part of British law since 1992. That means that common law must be interpreted in a way that's consistent with Article 3. And in the European Court of Human Rights, there have been several cases which have said that ineptitude by the police, a failure by the police to apprehend criminals, is a violation of the Article 3 rights of victims. That victims of crime have a right to freedom from inhuman or degrading treatment or punishment, and that a failure by the police to catch the perpetrator of the crime could be a violation of Article 3. And they said, taking that into account, we can change the view of the court in Hill and Chief Constable of West Yorkshire and say that in certain limited cases, particularly where the police has taken on the responsibility of catching a particular criminal, in order to be compatible with Article 3, there may be a duty on the police to take positive action to take reasonable care in conducting an investigation. So that's a big reversal, big development. And if you are studying tort law, the textbook probably won't include this 2018 case.
That's just to think about.
So have a look at this case, because I think it's a big one, does redefine duty of care, and it may not always be incorporated in your textbook. I think I'm going to stop there. I mean, what I've covered really is just the first step in duty of care. As I said, there are 4 steps: duty, breach, causation, remoteness. We're only looking at the first one, and we're only scratching the surface of the first one. There's a lot more I haven't covered. And all we're talking about in this class, actually, is the idea that there is a general duty on every person to take reasonable care to avoid injuries caused by their acts and omissions. It's not an absolute duty. It's not a duty to take absolute care. It's a duty to take reasonable care. And it transcends contract, it transcends other kinds of legal relationships, and it can be applied to any area of human activity. I'm going to stop there. Any questions or any thoughts?
This new development that you mentioned, wouldn't you be of the opinion that it's stretching the interpretation a little too far?
Yes. That's the danger.
Too creative?
Yeah. The danger is that it could potentially open duty of care to public authorities in very unpredictable ways. This has happened before, by the way. It happened in the early 1990s, and then it closed down again. So I think that if this door opens again, it will be opened in a much more gradual way, and it will also follow the jurisprudence of the European Court of Human Rights. So I think there's plenty of jurisprudence that can be used to guide courts in relation to this new development. Also, I think it only applies where a public authority has already taken on responsibility for a particular situation. So, let me just draw a distinction. Let's say fire brigade, and there are many cases of fire brigades. Let's say fire brigade is called, and they go to a scene, and they start putting out the fire, but they make it worse. Okay? Now, I would say, under the principles of Donoghue and Stevenson, Caparo, and even Hill, and certainly this recent case, I would say in that situation where a fire brigade makes the situation worse, they have a duty of care. Because they've acted, they've taken on responsibility. But let's say you've got a really lazy fire brigade, and the phone rings. This would be me if I was the fire brigade. The phone rings, and I would say, well, my lunch break, I'm really going to get that. I get this, I'm going to have to put on this just stupid suit and get a fire engine, rope build fire. I don't answer the phone. In that situation, I think the fire brigade would still not owe duty of care because they have that. They have to take on the responsibility. Once they take on the responsibility, once they pick up that phone, then that's where their obligation starts. That's where the duty starts. So in relation to this case, once the police took on the responsibility of this particular case, then they were duty.
So they don't have a responsibility to take on a responsibility.
No. They just have a duty that's triggered by the taking on of the responsibility. Any other thoughts or other questions?
I think we can take a break. Thank you very much.
Okay, break it is. Thank you very much. Thank you.